We're all looking at the screen. Whatever you put on the screen,
that's fine.
You can ask her a question about it.
Ms. Britt, why scan this in the screen, go through its phasing? Are you familiar with the case summary for case 1995 DR 6110? I don't hear.
I'm only familiar with the recent things that I can see on my side in my department as I am department reporting.
Okay. Can you see page 70 of the 120 pages submitted that comes from Division YD, which is I guess titled Case Summary Case NO.95-DR-006110 Smallwood versus Doss?
If that's what you're showing on the screen, sir, then yes.
Do you have any reason to believe that it's not authentic?
I don't know what you want me to.
Do you believe it's a clear record of the clerk's docket for this case?
As far as I can tell, but again, this isn't my department.
The department would object. She's not the proper person to authenticate whatever these documents are.
I mean, I think it just seems redundant because I've already taken notice of the record. Mr. Doss, your recitation of the facts, I don't think that there's anything incorrect in what you're saying in terms of the delay in service. This is all something that I wrote about in the previous order. Yes, there were delays. There's a 120-day rule that requires service. Didn't happen on the second petition. Didn't happen on third petition. I mean,
and it's your position that the 120-day rule does not apply to me?
No, it applied then, but you're bringing it up 2 decades later.
Is it your position, Mr. Denton, that subject matter jurisdiction cannot be challenged at any time?
No, my position is the link that you're failing to connect for me is why this is something that you're able to challenge under 12540.
It's a void order.
Okay.
And unless you have some case law, and not whatever you cited didn't make any sense, which I was kind of disappointed. I actually thought you were a little bit more competent than that. The case law that you cited does not have anything to do with the issue of subject matter jurisdiction in the 120-day rule.
Subject matter jurisdiction, I don't think was raised in the previous motion.
Of course it was. Of course it was. Of course it was. We're not going to do that. It was challenged back in 2013.
Again, are we reconsidering the prior order in the prior motion? Is it a new motion? Are we focusing on the driver's license?
No, what I want to focus on is the underlying order. Because from that, everything else stems. If the underlying order is no good, nothing you've done is any good. So, but anyway.
Did you have any other questions?
I have plenty of them. I wish you would quit interrupting me.
Your Honor, it's 5 o'clock. It's past
hey, you said it for 4 o'clock. Mr. McCarthy, I don't know if you have to go eat or whatever you have to go do, but the bottom line is this.
I have to go visit my friend whose child is in the hospital with me, so I do have to leave soon.
Well, then I want you to do your job.
We're not much past 5, Mr. Doss. So if you can
listen, wait a minute. What you can never do is use time as a basis for denying me due process. I know that for a fact.
If you can't complete your argument and
the argument,
I hear the same thing over and over in terms of what you're saying to me.
Mr. Denton, I wish, you're a hearing officer, but for some reason you always find yourself in the middle of these hearings. Your job is to hear and rule on the facts.
And I've been listening for 45 minutes.
Hear. Didn't say speak. Rule on the facts.
Move on.
Objection.
Move on.
I object to Mr. Denton interrupting my presentation. Mrs. Britt, do you see that stamp that's dated March, first day of March in 2024? Do you see that stamp?
Ms. Britt, you're muted.
Yes, sir.
Okay, do you have any reason to believe that the stamp is not authenticated by Adam Dungan, who is a deputy clerk?
No, sir.
Okay, thank you. Now, as we scroll up to see the converted new case, do you see that this case began May 15, 1995?
Yes, sir.
That was a yes, sir. Next question.
Okay, I didn't hear. I'm sorry, I didn't hear. Okay, and did you see that it was filed out fees on the same date, supposed to be here, and it was actually transferred from Leon County. You see that as well, correct?
Yes, sir.
Okay. And you also see that there was an amended petition on February 9th, 1998, correct?
Yes, sir.
Would you agree that that more than 120 days passed between May 15th?
Objection calls for a legal conclusion.
No, it doesn't. It's a
Let
factual
him finish
basis.
hang on. Let him finish his question.
Thank you. Would you agree that between May 15th, 1995 and February 9th, 1998, more than 120 days passed?
The department renews its objection that calls for.
Sir, if you stipulate that more than 120 days transpired between the 3 years of these two documents being filed, Ms. McCarthy, will you stipulate to that?
Yes, Your Honor.
Okay, I appreciate that.
Moving on. That's a fact in the record. Go
Okay,
on, Mr.
thank you.
Doss.
And would Mr. McCarthy also stipulate that between 1995 and 1998, there's no record activity of the department showing good cause for failing to serve?
The department would stipulate that this document shows no record activity between 1995 and 1998. That's correct,
Okay,
including no dismissal.
okay. And would you also stipulate to the fact that between 1995 and 1998, there's no record activity showing an attempt at service?
Run this document now.
Okay, thank you. That'll work. Okay, so we'll also stipulate that according to the record on September 10th, 1998, an amended petition for support was filed.
Yes.
Okay. Will you also stipulate that between May 26th, 1999 and September 10th, 1998, there was no service of process?
To clarify, do you mean no
No,
attempt at service of process or no
that wasn't my question.
successful
No
service?
successful service of process.
There was no successful service of process. There were attempts at process.
Will you, I'll stipulate that there appears to be one. We don't have any proof of that, but there's an alias. Will we also stipulate that there is no record proof that there was ever a court hearing where the department asked for an extension of time to serve service of process?
There's nothing on the record about that. I can stipulate to that. I was not working for the department or the Attorney General's office when all this occurred, so I don't have any personal knowledge as to what may have occurred otherwise at the time.
Will you stipulate that there was no evidentiary hearing to determine good cause for not serving from 1995 to 1990, February, from May 15, 1995 to May 26, 1999? Can we stipulate that there was never an evidentiary hearing to determine good cause for not serving process?
No, the department can't stipulate to that. I can stipulate that the record doesn't reflect any documents that would indicate that. But once again, I'm not aware of how the record was kept or how hearings were held back in the 1990s in this court. So it's possible that there were hearings that are not reflected on the court's record for one reason or another. So I can't stipulate that that definitely didn't happen. I can stipulate that the record doesn't reflect it.
Well, I'll stipulate I'll stipulate that the record doesn't show that it happened, and none ever took place as well. And by the way, you don't have to be working for the DOR or child support enforcement to just stipulate to the facts of the record, unless you're going to object to the record as being factually incorrect.
They've already stipulated to the record being admitted, so all this is redundant.
But no, are you stipulating that the record is correct?
I'm stipulating that the record is the record that the court kept.
Okay, well, I guess Mr. Denton.
Once again, I was not practicing law when I was 10 years old, so I do not know what the practices of the Circuit Court of Hillsborough County were at the time as far as what was and was not reported on their record. So I cannot stipulate any further than that.
All that wasn't necessary. The question was, do you object? You didn't object to the record being presented, right? To the record at all, right?
The record has already been taken judicial notice of multiple times in this case, and there has been no objection from the Department of Revenue.
Okay. Now,
for the purposes that the record can be taken judicial notice of.
okay, so when you go to 6/7/1999, do you stipulate that the record shows that a summons was allegedly returned, on 6/1/1999?
Yes, individual service on you on May 27th of 1999.
Okay, and do you stipulate that on 7/19/1999, the clerk issued a default judgment on that? Based on the record.
Well, it's not a default judgment, but a default was entered against you for failure to follow responsibility. Yes.
Okay.
It's not a default judgment. It's just it's not a judgment.
But it's a default, right?
It is a default. Yes.
Okay.